Good day everyone, we are Group 6 and we are going to discuss about Chapter 5, Interpretation of Contracts, Article 1370 to Article 1379.
Interpretation of contracts. It is the determination of the meaning of the terms or words used by the parties in their written contract. So, dito, inaalam kung ano yung kahulugan ng mga terms or mga words na ginamit sa provision dun sa mismong kontrata with respect to the intention of the parties. So, Article 1370, if the terms of a contract are clear and leave no doubt upon the intention of the contracting parties, the literal meaning of its stipulation shall control. If the words appear to be contrary to the evidence of intention the parties, the latter shall prevail over the former. 1281. It is the cardinal rule in the interpretation of the contracts that if the terms of a contract are clear and leave no doubt upon the intention of the contracting parties, the literal meaning of its stipulation shall control. The court must not read into any other intention of the contracting parties contradictory to the plain meaning. So, the general rule, A, is literal meaning controls when language is clear, and B, evident intention of parts prevails over terms or of contract. In this article, it states here that there is no need to interpret a contract if it is clear because the concern here is not what existed in the minds but what intention expressed in the language used. Also, when the words and clauses of a written contract are in conflict with the manifest intention of the parties, the latter shall prevail over the former, and it is the cardinal rule in the interpretation of contracts that the intention of the parties should always prevail, because their will has the force of law between them. For example, a contract was executed between Arena and Dexura. The contract recites that it is a sale of a shoes to Arena for 2,000 pesos. In the contract, Arena described as the vendor and Dexura as the vendee. The terms of the contract are clear and it does not appear from the circumstances that the intention of the parties is contrary to the literal meaning of said terms. So, malinaw na ito ay isang contract of sale. So, let's proceed to the Article 1371. Article 1371, in order to judge the intention of the contracting parties, the contemporaneous and subsequent act shall be practically considered. 1282. So, when we say contemporaneous, this will occur in the same period of the time. And the subsequent act is the one which is following in time or the order of the acts of the contracting parties. Note, this article only applies when the terms of the contract are ambiguous. For example, Angelica and Connie signed a lease agreement named Contract of Lease, despite the fact that the contract refers to Angelica as the lessor and Connie as the lessee. It indicates that Connie receives possession and ownership to the land. Angelica gave Connie the title to the land which she registered in her name. So, Connie wrote a letter to Angelica proposing to buy the land before the contract was signed. So, the parties' action plainly revealed that their apparent goal is to make Connie the land's owner. As a result, the deal should be construed as a sale. So, syempre, saan ka naman nakakita na nagpapa-open na transfer not only the possession but also the ownership of the property. So obviously after that, here based on the acts of the parties, contemporaneous kasabay also ng subsequent, binigay yung ownership, binigay yung possession, and subsequent sinabay sa execution ng contract of lease daw. Other is transfer to the title. So basically, yun yung subsequent act. Ito ay based on the acts and it's very obvious that the intention of the parties is to sell or enter to a contract of sale, not to a contract of lease. So, based on the act of the parties, saan ka naman nakakita ng nagpapaupa na yung nangungupahan pa yung nakapangalan sa titulo? So, obviously, the lessee or yung nangungupahan will get the possession. Siya na yung magpupwesto sa property. So, let's say it is house and lot. Siya yung magpupwesto sa property, yung nangungupahan. So, syempre, common sense na lang yun kung bakit mo naman uupahan kung hindi mo naman pupwestuhan, di ba? So, but in the example, take note that ownership likewise transferred to the lessee, so sa nangungupahan.
Article 1372. However general the terms may be, they shall not be understood to comprehend things that are distinct and cases that are difficult from those upon which the parties intended to agree. The rule in this article is that in a contract where there are general and special provisions covering the same subject matter, special provisions prevail over general provisions when the two cannot stand together. So based on the rule, no matter how general the terms used in a contract, they do not comprehend things that are distinct and different from those agreed upon by the parties. Kahit gaano pa ka-general yung contract, kaya siya ini-interpret para malaman kung mayroon bang distinct cases na nakapaloob sa kontrata na yon. In this article, it states that special intent controls over general intent. So no matter how general the contract is, there are still distinct cases that needs to be considered. A general contract is interpreted to determine if there are exemptions or if there are special provisions under it. So for example, Annie Dizon is an owner of a strawberry plantation. She appointed Christina Dizon, her cousin, to manage and have authority to do all acts and necessary premises within the plantation. Under this authority, Christina Dizon cannot sell even a portion of the plantation for the reason that it was not owned by her and was only appointed to manage the plantation of her cousin, Annie Dizon. For this example, medyo broad siya. Kasi nakalagay doon, Christina has an authority. Christina has an authority and to do all acts and necessary premises dun sa plantation. But management doesn't equate to ownership. Kaya pwede niyang gawin yung i-manage siya, pero hindi niya pwedeng kanyahin yung plantation. Article 1373. In Article 1373, it states that if some stipulation of any contract should admit of several meanings, it shall be understood as bearing that import which is most adequate to render it effectual. The rule is when an agreement is susceptible of several meanings, one of which would render it effectual, it should be given that interpretation. Thus, if one interpretation makes a contract valid or effective and the other makes it illegal or meaningless, the former interpretation is one which is warranted by the rules stated in Article 1373. To further explain this, if a contract contains different meanings, the ones that would make it effectual and is near to the intention of the contract, considering that is legal and valid, must be followed. There are simple contracts na madaling interpret or intindihin which can be under the cardinal rule of Article 1370, na if the terms are clear and leave no doubt upon the intention of the contracting parties, the literal meaning of its stipulations shall control. Pero kapag umira na yung stipulations of several meanings, dito naman papasok yung Article 1373. Yung mga contracts kasi na mahirap intindihan and medyo confusing because of several meanings. Kaya pag in-interpret siya, dapat ang masusunod dito is yung legal, yung valid, and effectual sa intentions ng parties sa contract. For example, Renato Batumbakal owns two houses. The one that he owns exclusively and the one that is conjugal partnership. Without specifying, Renato sells his house to Herman Baltasar. Renato's wife did not give her consent to the sale. In this case, the sale should refer to the house exclusively owned by Renato Batumbakal to make the contract effectual. Ito sa example kasi na to, siguro malilito kasi anong property yung ibinebenta ni Renato. But meron siyang isang house na sa kanya and the other is a conjugal property with his wife. And since hindi nagbigay ng consent yung wife ni Renato Batumbakal, it would be illegal kasi walang consent ng wife. So, ang may interpret dito na house na sinasabi ni Renato na binibenta niya is yung house that he owns alone. So, in Article 1374, the various stipulations of the contract shall be interpreted together, attributing the doubtful ones that sense which may result from all of them taken jointly. So the rule in this is a contract must be interpreted as a whole, and the intention of the parties is to gather from the entire instrument and not from particular words, phrases, or clauses, and all provisions should, if possible, be so interpreted as to harmonize with each other. According to this, a contract should be interpreted as a whole. Hindi siya pwedeng isang word lang or hindi siya pwedeng i-interpret by parts lang. Na kapag nabasa ng isang word, magko-conclude na agad or kapag mabasa yung 1 to 2 sentences, okay na. Dapat mabasa siya as a whole bago siya i-interpret. So for the explanation, it states that the various stipulations and the contract must be construed as a whole and is not only understood by parts. The provisions that covers the whole contract must harmonize with each other as to what it is interpreted, and it should be read according to its context and not by words, phrases, and clauses alone. So, to further explain this, if there are one or two or more separate writings in the contract, it should be read and interpreted together in a way na magiging effective yung intention ng parties. And dapat yung intention and provisions na nakapaloob sa contract na yun is harmonizing with each other. So for example, X pawned a ring to Y. In the contract, it was stated that Y agreed to not sell the ring until X is no longer solvent. In the same contract, it stated that Y will pay X 50,000 if he sells the ring. So kung babasahin lang yung isang sentence, like yung unang sentence ng example, makikita na bawal ibenta yung ring, which is bawal naman talaga sa kontrata nila. Pero dun sa second statement, merong babayaran if nabenta. So this doesn't mean na pwedeng ibenta yung ring. Bawal talaga siyang ibenta based sa kontrata nila. Pero yung 50,000 is the penalty. So hindi talaga siya pwede ibenta yung ring. Pero in case na mabenta nga ni Y, yung 50,000 is a penalty.
Article 1375, which means words which may have different significations shall be understood in that which is most in keeping with the nature and object of the contract. Requisite is different significations shall be understood in that which is most in keeping with the nature and object of the contract. Explanation is, words in the contract should be interpreted based on the nature and goals related to the intention of both parties. So, sinasabi rito na if yung contract daw ay merong dalawa o higit pang kahulugan, mas masusunod dito kung ano yung pinakamalapit na intensyon ng kontrata and dapat nag-serve dito yung objectives ng contract. Example, Ricky rented a roof from Eldon in order to construct an advertising sign. Ricky has the right to terminate the lease if a building of sufficient height is built on a neighboring property, obstructing the view of Ricky's sign. A sign was built on the roof of an adjacent building, blocking the view of Ricky's sign considering the nature and intent of the contract. The term building as employed in the contract may be read to include obscuring sign. Next is the Article 1376, meaning the usage or custom of the place shall be borne in mind in the interpretation of the ambiguities of a contract and shall fill the omission of stipulation which are ordinarily established. In this article, the places and acts term of a place where the contract was made should be considered. Dapat yung stipulation na nakapaloob sa kontrata ay dapat nakasunod sa kung anong mga polisiya na dapat sundin. Example is, Lito is a furniture painter who came from Manila. Their family moved into summer to live with his parents. Noli? Lito's neighbor bought a new chair and he wants it furnished. Lito rendered the service to Noli, and he accepted the rate he was given considering the difference between provincial and city rate. Next is Article 1377, which means the interpretation of obscure words of stimulation in a contract shall not favor the party of cause of security. In this article 1377, it states here that whoever caused the ambiguity must not favor. Kasi in creating a contract on them, must be careful and cautious with the words that they'll use. So if meron mang mali sa isang kontrata, hindi ito papabor sa kung sinong gumawa nito. Example, Pepito is a gardener. Pepito and Rolly made an agreement that Pepito will render Rolly a service to cut only a portion of grass in his garden. Rolly didn't give prior instruction on the particular area that Pepito will cut. In this case, Rolly doesn't have the right to complain as he didn't give specific place to where Pepito will render the service.
Article 1378. When it is absolutely impossible to settle doubt by the rules established in the preceding articles, and the doubt referred to incidental circumstances of a gratuitous contract, the lease transmission of rights, and in favors of the greatest reciprocity of interest. If the doubt are cast upon the principal object of the contract in such a way that it cannot be known what may have been the intention of will of the parties, the contract shall be null and void. To explain this Article 1378, when a certain contract had doubt from both parties or just in what the contract has spoken, the doubt can be classified either comodatum, undetermined, or void. To further explanation, this gratuitous contract explains that there will be doubt in a contract if the parties doesn't have a clear understanding whether the contract is a donation or a comodatum. Thus, if a party gave something to another party without clearing if it is a gift or donation, then it is subjective as comodatum. In onerous contract, if a party borrows with an undetermined timeline, example borrowing a money with interest, the due of payment would be classified for a year instead of 6 months. And for principal objective of the contract, interpret that if one party sold something that he had a lot without properly sorting which did he sold, the contract shall be void, or if the parties did not enter any contract. For example, Sally Season sells a portion of her land to an acquaintance, Tina Hertons. Sally owns a lot of lands, and they enter a contract without specifying which area will she sell to Tina. In this case, the contract will be considered null or void. Article 1379. The principles of interpretation is stated in Rule 123 of the Rules of Court shall be likewise be observed in the construction of contracts. To explain this article, that the contract should be interpreted when a party doesn't understand what was written in the contract, which is also connected to Article 1370. In accordance to Article 1370, interpretation of contract means that if it is formed is evident that the translation isn't questionable, then there won't be any interpretation, but the contract could be provided when there was a mistaken in the form of contract. The contract should be understandable for both parties, whether if it is for permanent investment or just rental. For example, X wants to buy a property from Y, and the next day, X gave the contract to Y, but there are a few things that Y doesn't understand under the contract. Hence, X should correctly explain and interpret what are the things written in the contract before Y sign.